All right, Mrs. Robertson.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I so do swear.
Please be seated and state and spell your first and last names for the record.
Mike Farrell, Mike-Farrell.
Mr. Darden.
Sir, were you a police officer employed by the LAPD on January 3, 1989?
Yes, I was.
And what was your assignment at that time?
I was assigned to West LA Detectives, assigned to the Crimes Against Persons detail.
And did the crimes against person detail include spousal battery cases?
Yes, they did.
Okay. Did you respond to 360 North Rockingham on the morning of January 1, 1989?
No, I did not.
You were not a patrol officer at that time?
That is not, I was not a patrol officer, no.
And on January 3, 1989, were you assigned a case involving Nicole Brown and this defendant?
Yes, I was.
Okay. And who assigned you that case, if you recall?
My supervisor was Detective Sergeant Glenn Varner.
And what is a normal procedure for a detective in West LA Division after a case is assigned to them?
Well, this case, after it was assigned to me, my supervisor explained to me what I should do with it and adjudicate it as soon as possible by interviewing the victim and the defendant, if possible.
And did you interview the defendant?
Yes, I did.
Did you interview him in person?
No, I did not. I interviewed him over the telephone.
Do you recall who called who?
Yes, I phoned the residence.
And how many times did you phone the residence before you finally spoke to the defendant?
Once. I believe I called on the 3rd in the later morning before the afternoon.
Okay. Now, had someone already prearranged a time when the two of you would speak?
Not that I recall. I just made my phone call.
Okay. And he picked up the telephone?
Yes, Nicole Simpson picked up the phone.
And did you next speak to the defendant?
After I spoke with Nicole, yes, I did.
Okay. And did you recognize the defendant's voice?
Yes, I did.
Was it a voice you'd heard before?
Yes.
And where had you heard the defendant's voice before?
Numerous times on television.
And did you ask the defendant about the occurrences of January 1, 1989?
Yes, I did.
And what did he say?
He explained to me that after he and Nicole returned home after a New Year's Eve party, that they were ready to, they're in their bedroom and a verbal dispute broke out between them. And that the dispute got out of hand and it became physical. He told me that it turned into a mutual type wrestling match. And that was basically it, nothing more than that.
Did you ask the defendant about the injuries Nicole Brown sustained?
Yeah, I asked him about because I had a photograph that showed injury to her forehead, and I told him that I looked at a photograph that depicted some injury to Nicole's forehead, and he said, well, I know, I was surprised to even see that even occurred because of the incident.
Did he deny causing those injuries?
No, he did not.
Did he admit causing those injuries?
Yes, he did.
You asked the defendant about the 911 call to police.
No, I don't think I asked him anything about the phone call itself, no.
Okay, so basically then all you asked him was what happened?
That's correct.
Now, after receiving this information from the defendant, did you write a report?
Yes, I did.
And did you include in that report the information the defendant gave you?
Yes, I did.
Did you continue to investigate the matter?
Yes, I did. I asked, after I did the initial telephone interview with the defendant, Nicole, I told Nicole that I would like to see her in person if she could make arrangements to come to the police station. She agreed, and she would come down the next day. She would also bring her 2 kids with her. And she did come down and meet me.
Okay. And so you did meet Nicole Brown?
Yes, I did.
What day was that?
I believe that was the 4th of January, the next day.
Okay. And what injuries, if any, did you notice on her face and neck and head area at that time?
I just noticed some bruising on her forehead. That was all.
The right side of the body.
And did you re-interview her?
Yeah, I explained to her what was going to happen in this case, and I explained to her the procedures that would happen. I reviewed the original police report with her and asked her to review it. We reviewed it together. I asked her, does this accurately depict what happened over the weekend? She said yes. I said, is this your signature on the report? She said, yes, it is. And then I explained that I would be preparing the case for a prosecuting attorney.
Did you refer the case to the LA City Attorney's Office?
Yes, I did.
And do they have a special unit that handles cases like these?
I believe they do. I met with the supervising attorney there and provided her with the information.
And what was the supervising attorney's name?
Mary Claire Molador.
Okay. You gave Deputy City Attorney Molador all the reports?
That is correct.
Did you show her the photographs?
Yes, I did.
How do we spell Molador?
I believe it's Molidor.
Thank you.
Do you recall the date in which you turned over your case file to the City Attorney's Office?
I believe it may have been the afternoon of the 4th or the morning of the 5th. I do not recall the exact time.
And after you referred the matter over to the City Attorney's Office, did you again speak with the defendant?
Yes, I did. He phoned me at my desk early in the afternoon. I believe it was after lunch.
Was the case against the defendant filed?
Yes, it was.
What was filed?
1 count of spousal battery. I believe it's 273A of the Penal Code. I'm not exactly sure.
Sure.
When you spoke to the defendant on the telephone, January 5, that call was January 5, correct?
That is correct.
Okay. When you spoke to him on the telephone on January 5, what did he say?
Well, Mr. Simpson phoned me, and he was inquiring about what this case status with his incident was. I explained to him that I had turned over the entire case file to the City Attorney's Office, and a decision had not yet been made. And the defendant and I did have a conversation. He discussed with me his feelings about the matter. He wanted to relay to me that he was sorry that the police had to come to his residence, and that me, as a detective, had to get involved in his personal problems. And he was really remorseful about what happened that day, and that he and Nicole were going to seek counseling to resolve their family problems, and that if I could relay that to the city attorney when they make their final decision in filing the case. I told Mr. Simpson I would do that, but I also told Mr. Simpson that it's most likely he is looking at filing for a criminal charge, and that he did one day have to face up to what happened and would have to answer for it.
Do you recall him saying anything else?
No, it was actually a pleasant conversation. I don't recall anything else.
Okay. Did you write a report in this matter?
Yes, I did.
I have a report here, Your Honor. It's dated February 8, 1989.
report, February 8th,
Yes.
89.
And before I proceed with the report, Detective, did the defendant describe for you or mention to you how Nicole Brown sustained the injuries she sustained?
Again, he explained that it was a result of an argument that they gotten into that resulted in a physical altercation, more of a mutual type wrestling match, nothing else.
Do you recall everything that was said in the conversation?
That's most that I recall. If I could look, if I have anything else I could refer to the report.
Would that refresh your recollection?
Yes.
May I, Your Honor?
You may.
I'd like to show the witness the report dated February 8th, 1989. Mr. Cochran has a copy.
All right, Detective, you can just read that to yourself, please.
Have you read the report, Detective?
Yes.
Does it refresh your recollection?
Yes, it does.
What else did the defendant say?
He told me that he was sorry for what he did to Nicole and that he didn't mean to harm her in any way and that he would seek counseling with her.
Didn't he also tell you that he knew that what he did was wrong?
Yes, he did.
Isn't that what you wrote in your report?
Yes, I did.
And when he told you that he didn't mean to harm his wife, did he elaborate on that at all?
Not that I recall.
He didn't describe the incident as a mutual wrestling match in this January 5 conversation, did he?
No, he did not.
Did he ask you not to file a case?
He asked me to relay his feelings about the whole matter to the city attorney's office.
And did you do that?
Yes, I did.
The report that you just read, dated February 8, 1989, that report wasn't in existence when you referred the matter to the city attorney's office. Is that correct?
No, I maybe have to make something clear on the report. It's dated 2/8/89. That may be a typographical error. The case was filed on January the 30th, 1989. And I may have typed the statement that he gave me that same day, and I may have put the wrong date on there. It should be, I believe it's 1/8/89.
Okay, but he did apologize for his conduct.
Yes, he did. He was very cordial about it.
Now, after you referred the matter to the city attorney's office, did they give you any further directions?
Yes, after some time, they asked me to look into the other incidents that were described by Nicole. She apparently told the officers who responded to her home that the police had been out there on numerous other times, and they asked me to look into that situation.
And did you look into that situation?
Yes, I did.
Did you determine that there were other situations or occasions when LAPD officers went to 360 North Rockingham?
Yes, I did. I inquired with some of the more senior officers at West LA that had been working the division for over the last 5 years and asked.
I'd like to object. You said it's not total response, it's required for me to be hearsay. I'm not sure of the response.
Sustain.
Okay. Well, what action? I'm sorry.
Question just a little overbroad.
What action, if any, did you take to determine whether or not other police units or officers had gone to Rockingham?
I spoke with senior officers at West LA and asked them if they had ever been to the location on Rockingham in the past.
All right, Mr. Darden, I take it you're about to launch into another line of inquiry at this point?
Did you do anything else?
Excuse me, Mr. Darden?
Yes.
I take it you're about to launch into another line of inquiry at this point?
Yes.
All right, we're going to take our afternoon recess, and at this point, if you recall our schedule for times, we actually get started at 1:30. We're going to take our break at 2:45 because it takes the sheriff half an hour to cycle the jurors. All right, ladies and gentlemen, we're going to take our afternoon recess for this afternoon. We'll resume at 15 minutes after 3. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions, have any contact with anybody, or conduct any deliberations, and we'll see you back here at 3:15. All right? We're in recess. Mr. Douglas, you had something you wanted to bring the court's attention before we invite the jury to join us?
I did, Your Honor. There was a letter that was transmitted to the court and a copy given to counsel concerning our supreme interest in quickly examining items of physical evidence. As the court is aware, the people have apparently now concluded their testing on items of evidence. There have been discussions from Mr. Blazier, Mr. Scheck, along with Mr. Clark and Mr. Harmon, and there has been an agreement that the items may be shipped to the forensics laboratory in Albany, New York, of Dr. Barbara Wolf, one of our doctors. We have not, in earlier occasions, had a chance to physically touch any of the items of evidence, any of the serological evidence, mind you. We had not had a chance to take our own pictures. We were hoping that this can be done soon, and we were seeking to introduce the protocol consistent with that which was used with Cellmark, so that they would be allowed to have a representative present for a chain of custody matters. They would be allowed to observe the cutting or the splitting of any samples. However, they would not be allowed to watch the actual testing so that we can maintain the integrity of our testing methodologies. I wanted to try to get some sort of closure on this issue so that we may quickly be able to get the items taken back, tested, and then returned before they'd be used in this actual trial. Given that we are currently on the domestic discord aspect of the trial, where the physical evidence is less probative or even necessary, I was hopeful that I could fashion some resolution today so that we could have those items sent out in the coming days.
Ms. Clark? Yes. I did receive a photocopy of the fax letter, and I don't recall, however, that was early in the morning as we were trying to deal with other matters. Ms. Clark?
Yes, Your Honor. I spoke to Mr. Douglas this afternoon, and he informed me at 2:45 that he wanted to address this matter at 3:15. I called upstairs to find out if I could get Rock and Woody here because they did have very specific requests about the procedures that they wanted to have employed. Unfortunately, they are at SID. They will not be able to make it until tomorrow. However, I asked that they be available first thing in the morning tomorrow to address it.
All right, that sounds reasonable. So, Mr. Douglas, I have not had the opportunity to read that letter because of the other matters we had this morning.
Very well, Your Honor.
All right, but
so we'll take it up in the morning?
First thing.
Thank you.
Great.
Thank you, Your Honor.
All right. Anything else before we ask the jury to join us?
Well, probably is, I think, to just have a abundance of caution, you should advise the court that after we finish this witness, I think before the next witness, Mr. Darden has indicated it'll be necessary to have perhaps a 402 hearing. He may have mentioned that to the court, so I wanted to let the court know.
All right, who's the next witness?
Ron Shipp, Your Honor.
Well, that's right. Okay.
So that may require a chamber conference before we
All right.
go on.
We'll start off in here.
All right, I'm aware of the issue. All right, thank you. All right, Deputy Magnolia, let's have the jury, please. Witness stand, Detective Farrell, you're reminded you're still under oath. And Mr. Darden, do you wish to complete your direct examination?
I have no further questions at this time.
All right. Mr. Cochran.
Very good, Your Honor.
Good afternoon, Mr. Farrell.
Good afternoon, counsel.
You are presently assigned to the West Los Angeles Detective Division, is that correct?
That is not correct. I'm currently assigned to West Traffic Division.
All right. You formerly worked West Los Angeles Detectives.
Correct.
All right. And how long have you been in the West Los Angeles Division altogether?
Approximately 7 years.
And you're a sergeant, is that correct?
I am a detective.
Okay. And before that, you worked as a sergeant?
I was a patrolman, training officer.
All right. And now you're working as a detective?
That is correct. I'm a detective supervisor.
All right. Now, in connection with this particular case, the matter was initially handled by an Officer Edwards, is that correct?
Correct.
And you had occasion to review his reports of January 1st, 1989, then you started handling the case as the detective, is that correct?
Yes.
And in that connection, you wrote some reports also, is that correct?
Yes.
And you shared with us that in the course of your investigation, you prepared a report. In that report, Mr. Simpson talked to you over the phone, is that correct?
Yes.
And what was the date of that? Was that January 3rd or thereabouts?
Yes.
All right, so the first time you talked to Mr. O.J. Simpson was January the 3rd, and that was in this phone conversation when you called his house. Is that right?
Correct.
His wife answered the phone,
That's correct.
and thereafter then you talked with him.
Correct.
Now, in that conversation, Mr. Simpson advised you that both he and his wife had been drinking after coming home from a party. Is that correct?
Yes, that's what I recall.
And they had been, as far as you knew, to a New Year's Eve party. Is that correct?
Yes.
Do you recall what time he indicated they came home from this party, sir?
No, I do not.
All right. And he told you that after that, after they come home from this party and had been drinking, a verbal dispute broke out. He
Yes.
told you that. And that he admitted that in this verbal dispute, there was a physical altercation that resulted in kind of a mutual wrestling type of altercation, is the words he used, right?
That's how he described it.
All right. And that he told you thereafter was that when he saw his wife, he was surprised to see a bump or a bruise on her forehead. Is that correct?
Correct.
And by the time that you had this conversation with Mr. Simpson, you, of course, had some Polaroid shots. Is that correct?
Yes.
Been taken? Do you recall how many pictures there were?
3.
And they were of Ms. Nicole Brown Simpson?
Yes.
And with regard to the Polaroid camera, do you know, or was there such a camera at West Los Angeles Station during the early days of January of 1989?
I would assume so. I have never used one.
All right, you would assume there was, and I presume that would be something that would be owned by the city of Los Angeles. Is that correct? Camera.
That or the officers themselves own them.
All right. And as such, the film, if the city of Los Angeles owned such a Polaroid camera, the film would generally be also owned by the city of Los Angeles, right?
You can ask him if he knows.
If you know.
I would assume so.
Right. If the city of Los Angeles does have the wherewithal to buy film, don't they?
I hope so, yes.
Yes, and they did back in January of 1989, did they not?
I believe so, yes.
All right. This is in Orange County. So we still have, we still
Not yet.
not yet. Not yet. We still have funds, right? All right.
We may have a significant impact on this, Mr. Franklin.
Well, Your Honor, then I better hurry up, so I don't want to cause any
I
further
think
delay.
we talked enough about
Right.
Polaroids.
At any rate, you're aware that there were facilities for taking pictures of individuals' injuries back in January of 1989 at West Los Angeles Station.
Not facilities that are designed to take photographs of injuries. We prefer to have the victim be transported to SID Photo Lab for proper photographic type things because they have better equipment, obviously.
I understand that, but I mean where you had a situation where someone was not transported to SID for photographs, you became aware that there was an ability at West Los Angeles Station to take photographs.
I assume that since I had 3 photographs given to me.
And you saw them. All right. Very well. Now, in your conversation of January the 3rd that we've been talking about, you spoke also with Nicole Brown Simpson. Is that correct?
Yes, I did.
And I presume, sir, that you had never met with or talked with either of these individuals, that is either Nicole Brown Simpson or O.J. Simpson, up to that point. Is that correct?
Yes.
Okay. And in her conversation with you, did she tell you what the...
Objection, Your Honor, form of question.
May I finish the question, Your Honor? I'd like to finish the question.
Just asking if she said something.
I was going to phrase the question in a way that you might not find objectionable.
Well, I'll hear the question.
All right? That's what I want to try to do. In your conversation with Nicole Brown Simpson, was the subject matter broached of what the subject matter broached of what caused this argument between she and her husband in the early morning hours of January the 1st of 1989? And I said yes or no.
She did not give me details about what actually caused the argument.
All right, now let me get back to my question. Was the subject matter of that argument, the cause of that argument, discussed? Yes or no?
Not that I recall, not the subject matter of what caused the verbal dispute.
All right. Did you at any time have a conversation with Detective Edwards wherein he indicated to you whether or not he'd been told what the subject matter of that argument was?
Not that I recall.
And you never saw any reports, did you? Any of Detective Edwards' reports? The subject matter of the argument?
I read his follow-up report, which I requested. But subject matter of the actual fight, no, I don't recall seeing anything like that.
All right. So as you sit here now, even today, you don't really know what caused this altercation or confrontation. Is that correct, sir?
No, I do not.
All right, sir. Now, you then had occasion, I guess, after the January 3rd conversation, which was the first one, to have a second conversation with Mr. O.J. Simpson.
Yes, I did.
And the second conversation was on or about January 5th, 1989. Is that correct?
Yes,
And in that conversation, Mr. O.J. Simpson contacted you. Is that correct?
that's correct. He called me at my desk.
And, of course, you recognize his voice again. Is that
Yep.
right?
Yes, I did.
And at that time, had you completed your investigation into this particular matter?
Well, as far as I'm concerned, I cleared the crime. I identified the individual who was responsible, and I believe I had enough to present to the city attorney's office to seek a prosecution.
All right, but as of the date January 5th, 1989, there'd been no determination made at that point whether or not the city attorney was going to file. Is that right?
Yes.
All right, and you so indicate that in your report?
Yes.
Okay. You completed your particular investigation, right?
Yes.
All right. And in this conversation that you had on January 5th, is this the conversation where Mr. Simpson voluntarily stated to you certain concerns and feelings that he had regarding this case?
Yes.
All right. Mr. Simpson told you, did he not, that he regretted the entire incident? Is that correct?
Yes.
That he was sorry that you, as a police officer, had to get involved in his personal problems?
Yes.
And he went on to claim responsibility and say that he knew what his conduct was wrong. Did he say that?
Yes, he did.
And he didn't mean to harm his wife, Nicole. He told you that, did he not?
Yes.
He went on to tell you that he planned to schedule both himself and Nicole Brown Simpson for counseling, did he not?
Yes.
And that he'd ask you to communicate that information to the city attorney's office when you took the case to them for filing or whatever. Isn't that correct?
Correct.
And in that conversation of January 5th, you told him at some point that you felt that at some point he had to stand up and admit responsibility for any actions that he'd taken on January 1st. Is that correct?
Yes.
And as the investigating officer, you are aware, are you not, that at some point thereafter, after January 5th, Mr. Simpson did, in fact, come into a court, enter a no contest plea, and resolve that matter. Isn't that correct?
Objection, calls for hearsay.
Overruled, he's the investigating officer. Do you know?
I never saw Mr. Simpson in court, ever.
All right. Well, you didn't see him in court, but you became aware, did you not, that the matter was resolved by way of a nolo contendere plea by Mr. O.J. Simpson. Is that correct?
Yes.
And as the investigating officer, you knew that matter was resolved without a trial. Isn't that correct?
Yes.
All right. Now, let's back up for a moment. Prior to Mr. Simpson entering the no contest plea, did Mrs. Nicole Simpson seek to drop all charges against him?
When I first met her on the 4th,
Objection.
What's the objection?
Can we approach?
Sure. Overruled.
You have the question in mind? I can try to phrase it again. Certainly, sir. Prior to Mr. Simpson entering a plea to this misdemeanor charge of 273.5 PC, did Ms. Nicole Brown Simpson indicate a desire to drop all charges against her husband and have a city attorney hearing?
well, when I first met her on the 4th, she brought the kids with her, and I discussed what happens with these type of cases. And I wanted her input about her feelings towards prosecution. At that time, she said if she could avoid it, she doesn't want to prosecute. But I told her that no matter what she told me, even though she didn't want to prosecute, I'd have to take the case to the city attorney's office. Then I discussed some of the options that the city attorney may do, and one of those is the city attorney hearing. And then at that time, she said, well, I would like to have that. I think that would be neat.
All right, let me just back up. In your report, you spell it out. On January 4th, '89, you contacted Ms. Nicole Brown Simpson. At that time, she told you she did not want to prosecute, but would welcome a city attorney hearing. That's an informal hearing at the city attorney's office, right?
Correct.
You sit around with the city attorney and you discuss this matter, right?
Yes.
And so thereafter, you told her that the city attorney could make their own judgment. They may want to go forward with the charges whether or not she wanted to prosecute or not. Is that what you said?
That is correct.
All right. And ultimately, we know that Mr. Simpson did enter this no contest plea to the misdemeanor charges, right?
Yes.
You were not in court that day, however.
Yes, I was.
All right, so you did see him enter the plea.
No, I never saw Mr. Simpson. I believe I went with with the city attorney, who was Rob Pringle at the time. I appeared at court that day, and I believe I stayed outside. They kept me outside in the hall.
Okay.
So they just told me what happened.
So you were in the hallway?
Yeah.
Okay. I understand. Now, just before the break, Mr. Darden was starting to ask you some questions about your investigation about other incidents involving Rockingham. And then we took a break. Is that correct?
Yes.
When you took the break, did you go up and talk to Mr. Darden about that?
No, we just went up to the office. I had a drink of water.
All right. He never asked you what the answer to the questions are going to be?
No, he did not.
He didn't say he was going to come back and not ask you those questions?
No, he did not.
What if I ask you those questions?
I'll answer them.
Do I want to hear the answers? I'll strike that. Now, at any rate, you, in the course of your investigation as one of the detectives, you told us just prior to the break that you had occasion to talk with some officers at that particular station. Is that correct?
That's correct. The city attorney asked me to look into possible other incidences up at the residence.
All right, so you talked to some officers. How many, just tell me a number, how many officers did you talk to altogether?
I can't recall, maybe 10.
And did you take any reports from any of those officers?
I requested, if they had any information, to write out a report and give it to me.
And you got a report from one officer, did you not?
That's correct.
And that officer's name is Mark Furman?
That is correct.
And was that the only written report that you received?
Yes.
And Mark Furman wrote you a report about an incident to which he'd allegedly responded at the Rockingham residence back in 1985. Is that correct?
He wrote a letter to the city attorney, yes.
And the letter he wrote in 1989 was referred back to an alleged incident in 1985. Is that correct?
Correct.
And would I be correct in assuming that that was the only letter that was sent to the city attorney in connection with the case of the January 1st, 1989?
That's correct. That's what I recall, yes.
And with regard to your search, did you search any records to see whether or not there were any radio calls to that location?
What the city attorney did.
Okay, I'm talking about you now, not the city
myself?
attorney. You, yes.
No, I did. All I did was contact the communications division of Los Angeles Police Department.
All right. So you did not check any records in West Los Angeles regarding possible calls that had taken place prior to January 1st, 1989?
I did my normal search of the computer.
All right. And you didn't find any calls, right?
None of them documented.
All right. And then by none of them documented, that means they weren't in the computer, right?
Police report.
All right. There were no police reports in the computer, right?
I couldn't find them.
All right. And you looked for them, and you were doing a diligent job, weren't you?
I tried.
All right. You were a responsible officer that time, right?
Yes, I am.
Okay. You're responsible today, aren't you?
Yes, I am.
Okay. You know how to use a computer?
Yes, I do.
Okay. You didn't find any police reports. And the only officer who stepped forward to write a report was this Mark Furman, right?
Yes.
And did you know Mark Furman prior to this particular time?
Objection, Your Honor. What's the relevancy?
I'll link it up.
He's been working West LA, and we all know each other at West LA.
So your answer is yes, you knew him?
Yes, I did know him.
All right. How did you happen to come to talk with him?
Well, he was one of the senior officers there. He was one of the officers that had most time there, and the city attorney asked me to look into the past 5 years, and he had been there at least 5 years.
All right. So when you told us about the talking to 10 senior officers, he would have been one of the 10 senior officers, is that right?
Yes.
All right. And then he then wrote this report. And was that report, the letter that he wrote around the middle of January of 1989, was that sent to you or to the city attorney?
I believe he gave me the original copy of it, and I in turn gave it to the city attorney's office.
And you're still in West Los Angeles now, are you not?
No, I am not.
And where are you now?
I'm at West Traffic Division.
All right. When did you leave the West Los Angeles division?
December of 1990.
You described when you were talking to Mr. Darden that your conversation with Mr. Simpson was a pleasant one, isn't that correct?
Phone conversation, yes.
Was it fairly common knowledge among West Los Angeles officers that on occasion some of them would in fact stop by Mr. O.J. Simpson's residence on a social basis?
I have no knowledge of that.
You had not done that yourself,
No, I have not.
but you don't know about any of the others, do you?
No.
But when you checked the computers for any other police reports or any other trips that officers had made out to the Rockingham residence after January 1st, 1989, you could not find any others after your diligent search. Is that right?
All I was looking for was
Before
documented
January
reports.
1st. And you could not find any
That is
documented
correct.
reports, right?
Not responses by police officers via the radio call, only documented reports, either by Mr. Simpson himself or Nicole. I did not find any.
Okay, that was the question. All right, thank you very kindly, sir.
Mr. Darden?
You indicated that the defendant pled no contest and filed a battery charge.
That's correct.
He didn't plead guilty.
No contest.
And in fact, he struck a plea bargain in that case, didn't he?
Yes, with the court report, please. All right, thank you, counsel. Mr. Darden, you may continue.
You also indicated that you had a pleasant telephone conversation with the defendant, detective,
Yes, I did.
but you weren't about to arrest him at that time, were you?
No.
Did you ask him why he fled the location on January 189?
Yes, I did. His response was that he was upset that the police were out there and weren't happy that the police were out there. And then that's when he decided to leave.
You indicated to Mr. Cochran, and you told Mr. Cochran that you were only searching for documented reports.
Correct.
Correct? Okay, you were searching for documented reports in your search for other situations where the police went to Rockingham?
Yes.
Now, there are other types of reports that officers fill out, is that correct?
Yes, there are.
They have logs, is that right?
Daily field activities reports. That's correct.
Okay. And what types of information would a patrol officer include on a daily field activity report?
That causes speculation. I didn't even further foundation. Can that question?
No, I think he testified that he's been a patrol officer, was a training officer. I think he has sufficient foundation to answer what this is. Sufficient experience.
The report itself documents the time the radio car gets the call, its location, type of call, and when the call is finished and what the officer actually did at the location. And it's all documented in the officer's own writing.
And that daily field activity report is a report completely different from the report filled out by Detective Edwards, is that right?
That is correct.
What's the difference between the daily field activity report and the report filled out by Detective Edwards?
The follow-up report filled by Detective Edwards is a continuation of the crime report. The DFARs that we call it is just a daily log of activities that the officers does in the field. It's not part of a crime report or anything like that.
Are DFARs or daily field activity reports computerized?
Not that I know.
Were they computerized back in 1989?
I don't think so. They were not.
How many officers were there assigned to West LA Division back on January 189?
Quite a few. And an exact number I don't know. Over 100.
And is that 100 per shift or 100?
I wish it was 100 per shift, but it's maybe about 30 officers per shift.
30 patrol officers per shift.
Correct.
And each day, each patrol officer fills out a log?
If they are assigned by themselves, yes, but most officers in the Los Angeles Police Department are assigned to 8 cars. That's 2 men to each patrol car. 2 officers, I'm sorry.
So had you gone back and searched all the DFARs for the 5 years prior to 1989, that would have been quite a job, right?
That's correct.
The question, object to the form of that question.
Well, it's an innocuous point.
That would have been quite a job, right?
Yes, it would have.
And you would have had to have done a hand search.
Correct.
You also indicated that Nicole Brown asked that you not prosecute the case.
Yes.
You've had training in domestic violence, haven't you?
Yes, I have.
That's not uncommon for domestic violence victims to...
Object.
Sustained.
Now, you heard, Your Honor?
Yes. At the sidebar with the court clerk, please. All right, thank you, counsel. Mr. Darden, you may continue.
I'm sorry, was the objection sustained, Your Honor?
The objection is sustained pending a foundation.
Detective Farrell, what training, if any, have you had in domestic violence?
Basic academy training when I first came on the police department. Also in-service training with the Los Angeles Police Department on domestic violence.
And did you take a course?
Yes, I did.
And how many hours?
It was a 3-day in-service training for advanced field officers, which I believe totaled a 24-hour course.
And have you responded to domestic violence calls in the past?
Yes, I have.
Many?
It's quite a few, yes, sir.
How many would you say?
I could only say hundreds.
Okay. And have you been the investigating officer on domestic violence cases in the past?
Yes, I have.
And have you participated in the prosecution of domestic violence cases in the past?
Yes, I have.
Have you read literature having to do with domestic violence?
Yes, I have.
Have you read literature having to do with the causes and effects of domestic violence?
Yes, I have.
Have you spoken to victims of domestic violence?
Yes, I have.
And have you watched them testify?
Yes.
Have you spoken to others who are professionals and who are experts in the area of domestic violence?
Yes, I have.
And have you ever testified in court as an expert on domestic violence?
I have never testified as an expert.
Thank you, Your Honor. Nothing further.
Any recross?
Yes, Your Honor, just a couple questions.
Secretary Farrell, when you were asked by the city attorney to try and determine whether or not there had been other calls in the 5 years or so that preceded January 1st, 1989, did they give you kind of a blanket instruction to do the best that you could?
Yes.
And you, in the course of trying to carry out their request, you did the best that you could, did you not?
Yes.
And then you then reported back to them after you had done the best that you could. Is that correct?
Yes, I did.
And in doing the best that you could, you got this one letter from Mark Furman. Is that correct?
Yes.
Thank you very kindly. I have nothing further.
Mr. Darden?
Nothing further, Your Honor.
All right. All right, Detective, thank you very much. I'm going to excuse you from further testimony. Please don't discuss your testimony with anybody else except for the attorneys in the case.
Thank you, Your Honor.
All right, thank you very much. All right, Mr. Darden, as to the people's next witness.
Your Honor, before we call the next witness, I have in my hand here what appears to be a Xerox copy of a single-page letter. It is dated January 18, 1989. It was directed to the city attorney for the city of Los Angeles, and it is signed by Detective Mark Furman. May it be marked People 7 for identification.
People 7. All right. Mr. Darden, how do you wish to proceed at this point?
I think we should resolve the preliminary legal issue that we have to resolve.
All right. Ladies and gentlemen, I have a legal issue that I need to resolve before the next witness can be presented. And given the lateness of the hour this afternoon, I'm going to recess as far as you are concerned this afternoon. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case. And you are not to perform any deliberations till the matter has been submitted to you. Have a pleasant evening. We'll see you back here tomorrow morning, 9 o'clock, and we'll have more witnesses for you. All right, see you tomorrow. All right, good morning, counsel. Back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark and Mr. Goldberg. And we had a preliminary matter to settle before calling the next people's witness. in the nature of an objection regarding certain content of the statement. We're now joined by Mr. Darden. Good morning, counsel. All right, Mr. Douglas, I've reviewed the Estes case, 82 Calap 3rd, 509, Estes, E-S-T-E-S. And I've also reviewed the memorandum of points and authorities filed this morning by the prosecution and specifically by Ms. Lewis.
Your Honor, this morning we found a couple of additional cases that we wanted to cite to the court and counsel. I apologize for not having them in the points and authorities. One was People versus Bowe at 1 Cal 4th, 281, and the relevant discussion starts on 302. And the other case is also a California Supreme Court case. People versus Pride at 3 Cal 4th, 195. Relevant discussion starts on 234.
Regrettably, Your Honor, I've only this morning had a chance to briefly peruse the memorandum that was submitted. I have not, of course, had a chance to review these cases or their applicability to the issue at hand. I expect that my cross-examination of this witness is going to last for at least a couple of hours. I would like, before I am required to respond with any in-depth analysis, to at least be given the chance to review these cases, to examine them. I believe, Your Honor, that the statute about which we concern ourselves is clear. I offered a parallel to that statute in the Estes case, though it is not the exact statute. I do think that the reasoning of that statute is very applicable to the issue at hand. I do think, Your Honor, that there is another threshold issue that is raised, and that is one of 352, as to the probative nature of the substantive statement, even in any excised form. I think that there is a tremendous question in the scientific community as to the predictive nature of certain statements about which we concern ourselves. They are not predictive of events that may have occurred in the past or predictive of things in the future, and that entire issue is one that is most properly the subject of expert testimony. There is the very strong likelihood that it is going to necessitate confusing of issues, the undue use of additional time, the certain calling of different witnesses who might be experts on this area, who might then be able to place these statements, even in its excised form, in a greater understandable context for the jury. I offer to the court my opinions, as I did at sidebar, that I cannot properly address the circumstances in which the statement was allegedly given, and for the record, we will deny that the statement was even made, and we will strongly challenge the factual predicate for the giving of the statement, such that we would think it proper that there be a hearing consistent with Evidence Code 403, laying the foundation for the preliminary fact that, in fact, this statement was even given. For all these reasons, Your Honor, and given the fact that I have not had an adequate chance to properly cross-examine or to properly review these cases, that we be allowed to examine this witness, because I'm ready to examine this witness on matters other than this disputed area, that I be given adequate time to do my own independent research given this new information, and that the witness be recalled later in the trial, or that that portion of his testimony be held until later.
Mr. Goldberg? Mrs. Robertson, let me ask you to, if you would, make 2 photocopies of the relevant portions. Thank you.
Your Honor, apparently the defense has been aware of the statement since January the 22nd, and obviously if there were any issues as to legal admissibility, there was plenty of time to research those, to address those today. Obviously, the prosecution wants to put the statement on as part of Mr. Shipp's testimony. There's no reason for breaking up his testimony and having him come back later after counsel has had an opportunity to do further legal research. Does the court want the prosecution to address our theory of admissibility now and the issues regarding the statement?
Yes.
Okay. I'd first like to start out with a discussion of the relevancy of the statement, because I think counsel seems to be suggesting under 352 it's not admissible. And any discussion probably should start with an issue of why is it probative, why is it relevant? And then I'll get into the issue of the polygraph aspect of the statement in the second part of my response. As to the probative value of the statement, Your Honor has ruled already in the context of the domestic violence evidence that the prosecution is entitled to put on evidence in this case, and apparently spend a significant amount of time doing so in what I think the court characterized as being the equivalent of several misdemeanor jury trials. We are entitled to put on this evidence for the purposes of showing the defendant's mental state and showing his intention at or around the time of the murder.
But the controverted statement, though, is the very next day. So, I mean, we're out of the category of domestic violence, wouldn't you say?
I just want to tie it into why it is relevant in the context of all of the evidence that the court has allowed. The purpose of that evidence is to allow the jury to infer something circumstantially about what the defendant was thinking at or around the time of the murder, what his mental state and his motivations were. It's circumstantial evidence because the inference, the chain of inferences, is that we can determine from his conduct what his intention, what his mental state must have been. The evidence pertaining to Mr. Shipp differs in only one respect, and that is that instead of being circumstantial evidence of his intent and his mental state, it's direct evidence, because it's him saying, this is what I've been thinking, and from the context of the statement, it was over a period of time. Now, the distinction there between direct and circumstantial isn't particularly important. What I would suggest to the court is important is the way that the respective sides have asked the jury and this court to interpret the circumstantial evidence. Because what we've said, Your Honors, we've said, look, what this evidence shows is it shows that the defendant had an obsession with Nicole Simpson, and that it was an obsession that led to her murder. I guess what we could term a fatal obsession. Isn't that precisely what the statement to Mr. Shipp is saying? I have been dreaming about killing my wife. Isn't that powerful, powerful evidence of that fatal obsession, except that instead of coming in the form of circumstantial evidence, it's coming in the form of direct evidence. The defense, on the other hand, has a different interpretation of the domestic violence evidence. They say, no, it's not really evidence that shows the defendant's state of mind in terms of a fatal obsession. What it really shows is a cycle of benevolence. And they're entitled to make that argument, Your Honor. We're not saying that that is improper. That is a proper jury argument. But when they are allowed to stand before the jury and say that all the circumstantial evidence that the prosecution has introduced simply shows a cycle of benevolence, and we have direct evidence which conclusively shows that that isn't true,
Well,
that he really...
Let's sort of leap ahead to what really concerns me, because
Okay.
I agree with you that it's an interesting statement. Were I in your shoes, I would probably want to get it before the jury. What concerns me about this is two things. One, the 351.5 prohibition of any mention of polygraph or lie detector, which is included in the context of this statement. And secondly, whether or not it's fair or somehow fundamentally misleading to the trier of fact to pluck this sentence out of the context in which it was said, which is beginning and ending with comments about polygraph. So is it fair to pluck this out? That's the concern that I have.
Okay.
Mr. Goldberg.
Thank you.
I mean, that's the issue that I see. Assuming you get over the relevance question, assuming I agree with you that it has some probative value and would be of interest to the prosecution case, and that it clearly is virtually contemporaneous to the acts in question.
Yeah,
What concerns me is the context.
Okay. Yeah, I suspected that, Your Honor, that is where the court's focus was
So
going to be.
why don't we
And-
jump to that?
Okay, but let me just point out, the only reason that I was talking about relevancy and probative value is that there's a spillover effect on this question that the court's concerned of can you sever part of the statement out and then leave the portion about the defendant dreaming about killing his wife, and is that fair?
Well, Mr. Goldman, let me ask you this, because yesterday in the discussions that I had, nobody gave me a precise offer as to exactly what statements were going to be offered.
Okay, let me read the entirety of the statement, including the portions that I believe the court finds to be objectionable, as well as those that the prosecution wants to introduce. Excuse me?
Go ahead.
Thank you. I was interviewed by detectives and they asked me to take a lie detector test. And I replied, well, what did you say? This is Mr. Shipp talking. And he kind of chuckled and he says, hey, to be truthful, Ron, man, I've had a lot of dreams about killing her. And he says, I really don't know about taking that thing. He did not say he wouldn't take it. He says, I really don't know about taking it. So that is the full context of Mr. Shipp's statement to us. The portion that we want to introduce is merely the portion that says, hey, to be truthful, Ron, man, I've had a lot of dreams about killing her, unquote. That's the portion that we're interested in. But to get back to the issue that the court addressed, the reason that I made some comments about relevancy is that in our state, under our Constitution, Article 1, Section 28, we do have a right to truth and evidence in the state. And there are only certain specified exceptions to that right. And those exceptions are that a statement can be excluded. The statement can be excluded, or evidence can be excluded if it's privileged, which this isn't, if it's hearsay, which this isn't, if it's 352, which this isn't, if it's protected by the rape shield law that's codified in 1103 and 782, which this isn't, or if it's taken in violation of the federal Constitution, which it isn't. And that's what the Constitution says of our state. It shall be admitted. This is highly relevant evidence, and it doesn't come under any of the exceptions, and therefore should be admitted. Let me just point out that as to the statement, that the context of the statement was relating to the police interrogation, just to put the quoted portion in context, Your Honor. He was talking about his conversations with the police in the context of making the statement that I previously quoted. Therefore, the issue becomes, Your Honor, are we somehow going to, contrary to the clear policy of the right to truth and evidence provision, exclude highly probative evidence, evidence which really seems to blow a hole in the defense theory of a cycle of benevolence, simply because contained within that statement there are other materials that Your Honor is rightfully concerned about, which are inadmissible. And clearly the law of the state does not lead us to what in our view would be an absurd conclusion. I'd like to get into that legal issue now, which is, I think, what is at the forefront of the court's concern. And starting with Evidence Code Section 356, which I believe is a section that's relied on by counsel, which, like Evidence Code Section 352, I think has been oversimplified again and again by attorneys and misstated by attorneys in terms of what it really stands for. The court may recall that when we addressed 352 last, I pointed out that oftentimes attorneys talk about something being more prejudicial than probative. And they cut out that word substantially more prejudicial than probative. Over and over again in our courts, we see attorneys saying, well, Your Honor, if they put in part of the statement, I get to put in the whole statement. I think Your Honor's probably heard that. And that is not the law of the state of California. It never has been, yet it's continuously repeated as if it were handed down by Moses from the Mount. It is not what Evidence Code Section 356 says. It's not what the cases say that interpret that statute. What the statute stands for is the very common sense proposition that when you put in part of a statement and the other side can demonstrate that it is necessary to put in another part of that statement to put it in context, that that can be allowed. And there are a number of cases that interpret 356 in that way, one of which we cited in our brief, the other two which I provided this morning. One being People versus Bowe, that was at 1 Cal 4th, 281. And what it says of Evidence Code Section 356 is, quote, "The section permits introduction only of statements on the same subject or which are necessary for the understanding of the statement already introduced. The other conversation referred to in the Evidence Code Section 356 must have some bearing upon or connection with the admissions or declaration in evidence." So in other words, when we needed to put something in context, then we can use Evidence Code Section 356 to do that. I think the case of People versus Pride is more instructive for Your Honor. And there what happened at 3 Cal 4th, 195, is the defendant gave a very lengthy tape-recorded interview to the police that occurred over a course of approximately 2 hours. And instead of introducing the tape recording, what the prosecution did is they called the detective that took the statement to the stand, and they asked him about only one tiny little snippet of that conversation. That was a statement to the effect that the defendant accounted for his whereabouts, and those whereabouts were false. So the prosecution simply wanted to prove that in a couple sentences of that lengthy interview, he had made a false statement. And the defense says, well, we want to put in the whole thing. We want to put in the whole thing to show that maybe the defendant's state of mind was such that he was confused or wasn't really focusing in on what the detective was asking him. We want to put it in maybe to show that he was giving an estimation or an approximation in accounting for his whereabouts as opposed to a definitive type statement. Trial court there did not allow it in. And what the California Supreme Court held was that it was properly excluded because they reviewed the tape themselves and they found that it would have been an abuse of discretion to admit the rest of the tape because it did not support the defendant's theory that there was psychological coercion. It did not help to explain or account for the statement. And in fact, the tape amply supported the prosecution's theory that the defendant gave a positive accounting for his time, which turned out to be false. So they held that if the court had admitted it, it would have been an error. So I think that very, very strongly supports what the prosecution is asking Your Honor to do here. Now let's take a look back at the defendant's statement to Mr. Shipp. The quote being, "Hey, to be truthful, Ron, man, I've had a lot of dreams about killing her." In and of itself, the statement is perfectly understandable. It is perfectly clear. It's the defendant saying, I've dreamed about killing this woman. It's very simple, very straightforward. What is the statement that immediately preceded that? "I was interviewed by the detectives and they asked me to take a lie detector test." And then he chuckles. How does that possibly put any different spin on the statement? It doesn't explain the statement, qualify the statement, retract the statement. It doesn't do anything to make the statement more understandable. How does the fact that he says, "I was offered to take a lie detector test," either contribute or detract from the statement that he was dreaming about killing his wife? Does it make it more likely that he was dreaming about killing his wife or less likely? I'd submit to you that it is logically entirely irrelevant. And that this is evidence, this is a statement which stands alone, which is perfectly comprehensible, perfectly understandable in and of itself. And that if you subtract the parts about the polygraph test, you don't lose anything at all. And I think the defense will have difficulty articulating why you did lose something. But even if they can, then I'd ask the court to refer back to People versus Pride, where the defense threw out some theories there as well as to why they needed the entire tape. And the court reviewed it, made its own determination, and said, no, I don't buy that. That doesn't explain, qualify, or in any way detract from the statement. And it was upheld by the California Supreme Court.
Right. How does but we have sort of the inverse situation here where they don't want the context because of the discussion of polygraph and the negative implication that can be drawn from that by the trier of fact not fully aware of the nature and circumstances of the admissibility of polygraph evidence.
Well, then it sounds like if that's the case, we're all in agreement. I mean, then I really don't understand what the argument is about. Because if we're saying all we want is the statement and they're saying all we want is the statement, where's the disagreement?
I'll hear what their position is in a second. I'm just asking you, since it's the inverse situation, really.
Yeah, I think that what they're trying to do is essentially saying, well, we don't want the statement either, but if we can, we're going to say that we want the statement, kind of, because maybe if we do that, the court will throw the whole thing out, the baby with the bathwater. And the analogy that I come up with there, Your Honor, is it's very analogous to the situation that Your Honor has undoubtedly confronted in the context of Aranda issues, where the prosecution wants to introduce the statement of the defendant, which implicates the co-defendant. And we say, well, Your Honor, just redact out the stuff that refers to the co-defendant so we can have a joint trial of these two defendants. That attempt is always going to be foiled, or they're always going to attempt to foil it by saying, well, Your Honor, we have to put in the co-defendant statement in order to place into, we have to put in the statement that refers to the co-defendant in order to place into proper context our client's statement. And in reality, what I think is happening is an effort to put in something that really doesn't logically help them for the purposes of getting a severance. Yet the courts have over and over again, and perhaps Your Honor has been in the situation, redacted those statements under Aranda and said, no, you can't put in your client's statements which implicate the co-defendant because they aren't logically necessary here. The other analogy I give the court in terms of practical situations where this comes up is in the context of a defendant's confession where he, in a lengthy tape-recorded statement where many, many topics are discussed, discusses things that are clearly inadmissible. For example, sometimes defendants will talk about their prior criminal history, what they were doing in state prison, things that clearly don't come in, and those are redacted out all the time. And I don't think the defense can be heard to say, well, those are prejudicial to us, so we don't want them to be heard by the jury. Therefore, you have to throw out the whole statement. I mean, I understand that the defense here is in a tactical bind. I mean, they don't want the statement about polygraph to come in, but apparently they also want to argue that it should come in order to get the whole statement removed. And I just don't think that that's a consistent position. They are going to be able to address us, and maybe we'll hear and they'll clarify what their position is. Maybe they'll clarify that indeed we all are all in agreement here. That statement doesn't come in pertaining to polygraphs, but the portion about wanting to kill the wife stands alone. It's highly relevant, and it should be admitted.
All right. Thank you, Mr. Goldberg. Mr. Douglas, you've been given photocopies of People versus Pride and Breaux, B-R-E-A-U-X.
I have had a chance to read the cited portions of the cases that Mr. Goldberg referred to, and I appreciate the court's convenience in that matter. Let me begin by saying categorically that we deny that the conversation ever took place or that the statements were ever made. That the court must understand as a predicate so that the court can appreciate the seriousness with which I will then have to cross-examine the witness about the entire conversation. I'm not sure how many people charged with murder Mr. Goldberg has ever represented, so I don't know how he is able to get into the defense attorney's mind and to understand what it is that the defense attorney has to do. But, Your Honor, let me tell you, there is a statement that is made in connection with a conversation about polygraphs. And most importantly, right before the question comment is made, there is then a chuckle. He kind of chuckles then. Your Honor, as the court understands as a former defense attorney, I am going to examine this witness about everything given the context of that conversation. Because, as I said as a predicate, the conversation did not occur. And I am going to try to demonstrate that he's lying when he says that Mr. Simpson told him that there was a dream about killing his wife. But, Your Honor, we have a problem that Mr. Goldberg's memo a problem that the Pride case, a problem that the other case does not address, and that is Penal Code Section 351.1, which is a code section standing alone, which says, notwithstanding any other provision of law, the results of a polygraph examination, the opinion of a polygraph examiner, or any reference to an offer to take, a failure to take, or the taking of a polygraph examination shall not be admitted into evidence in any criminal proceeding. I am then in a quandary. Under no circumstances is the law enabling anyone, and I'm not going to waive that code section's applicability to this case, but in no sense does the law allow any discussion, reference concerning polygraphs to be admitted. Yet, in the statement where I must attempt to challenge the authenticity and the accuracy, there is a chuckle. Query, what does that chuckle mean? Does that chuckle mean that Mr. Simpson is taking a flip sense of the whole concept of a polygraph? Does that chuckle presage the joke that was made by the question language, such that the jury can understand that the question language was given in terms of a joke because the speaker has a general flippant, joking sense of polygraphs in general? I am unable to challenge that. I am unable to put this statement, which I say never occurred, in any kind of a context. And that is unfair. That denies me due process rights. That denies me confrontation clause rights. That violates Mr. Simpson's Sixth Amendment rights under both the California and the federal Constitution. And that is not just a technicality, Your Honor. That goes to the very essence of what a fair trial is all about. I cannot challenge a statement that I say never occurred, a statement where there is, even from the mouths of the witness, information that might suggest that the statement was not offered in total seriousness and true appreciation for the value of that statement. And there's another problem which runs into 352. I am informed, although I have not spoken to anyone professionally, that whenever there are statements of dreams or questions of dreams, it is not necessarily indicative of the state of mind of the speaker. It does not necessarily mean that if he dreamt something, it is relevant to an issue in the case that he killed her, and that there is a misconception that Mr. Goldberg apparently holds as well, that there is some probative nexus between someone saying that I dreamt about something, assuming for the sake of my statement that the statement was made, and that it means something that is relevant to the trier of fact. Therefore, there is going to be a great deal of scientific testimony that I will have to try to obtain to put on people that will be able to talk about dreams, and particularly in the context when this man is told that very day that a woman with whom he had been involved for 17 years had just died, and he is going through, and he wasn't around, and he is told on the telephone that this happens, and he rushes back, and he is consumed with all of this grief and all of this uncertainty and all of this emotion, and he is tired because he didn't sleep going to Chicago and didn't sleep coming back, and there are these family members that are also grieving with him. There is an entire context, Your Honor, that it would be unfair to require that we simply examine under a microscope 6 or 7 different words without appreciating the entire context in which it's offered. I argue, Your Honor, that on this level, the answer is clear. When you must balance the obligations of the people and their interest in getting in this evidence against the possible danger of unfair prejudice, against the potential for consuming undue time, against the inability for me to vigorously contest the very context in which the statement is weighed, the results are clear, and you should rule in favor of not allowing the statement to come in.
Thank you, Mr. Douglas.
May I respond?
I'm interested, Mr. Goldberg, in Mr. Douglas's argument that what is the significance of dreams?
Well, yeah, I was very interested by that argument too, because it seems to be so preposterous. I mean, let's imagine, for example, Your Honor, that he simply had said, I've been dreaming about Nicole every day of my life, or I've been dreaming about Nicole constantly. Not that he was going to kill her, just that he'd been dreaming about Nicole. Wouldn't that in and of itself be relevant to show this issue of this obsession, this fixation on this woman, that he has not let go of it, let go of her? The fact that he's dreaming about killing her simply magnifies several hundredfold the relevance of the statement that he's been dreaming about Nicole. It's highly relevant and highly material here.
Are you going to offer some psychiatric or psychological testimony to back this up, that there's some probative value to this?
If it's admissible, we will. If the court, we've litigated extensively this issue of can we put in expert testimony, and I wasn't absolutely clear what the bottom line ruling of the court was on that issue. But obviously the court knows we would like to put on expert testimony. But I think that whether you have expert testimony or not, this is the kind of issue that people understand from their own experience. And we all have dreams, and every person on that jury does, and they understand from their own experience the significance of this kind of evidence. And I think even Your Honor, as a case of first impression, when I started addressing you this morning, cut me off, said, well, Mr. Goldberg, I can kind of, I'm paraphrasing now, I sort of appreciate the relevance here. I'm more concerned about this polygraph issue, because I think that as a matter of common sense, that a person looking at this, even on a case of first impression, is going to understand how highly probative it is. I'd also like to address some of the other comments that were made just a few moments ago. First of all, as to the chuckle. I don't understand the defense argument here. I thought we were going to get clarification, and now I'm even less clear. Do they want the statement about the polygraph in, or do they not want it in?
They don't want any of it in.
They don't want any of it in. We know that. But if they're going to get the statement about the dreams in, then I'm not clear. Do they feel they need to then bring in the polygraph for purposes of explaining it, or do they still not want to? I don't think that position has at all been clarified for us, and I think the reason that they're having difficulty clarifying it is because it seems like there's an inconsistency. I mean, on the one hand, they want to argue that it's inadmissible, and on the other hand, they want to turn it around and argue that it needs to be admitted for the purposes of clarifying the statement. And I think that should be interpreted as what it is. It's they're staking out a position that is designed to maximize the likelihood of, as I said, throwing out the baby with the bathwater, rather than specifically telling you what it is that they want and what it is they don't want. But the chuckle itself, we have no objection to. Now, counsel says, well, I want to show that the chuckle relates to the polygraph test. In other words, I want to put the chuckle in context. Why? How does that help their position, that the defendant may have had a flippant attitude about polygraphs? What on earth does that begin to say about the context of the statement that we're concerned with about dreaming about the murder of his wife? That's the statement we're interested in putting into context. What Mr. Douglas should have argued is he should have argued that somehow the chuckle reflects upon that statement. But to the extent that it does, the chuckle can come in. Again, this is why I think that the case of People versus Pride is particularly significant, because, we don't expect the defense to roll over and say, look, we really don't have a good theory on this. They're going to come up with an argument as to why it is that simply taking that one statement is going to be out of context, and why it is, I suspect, that they need to put it back in context, just as the attorneys did in Pride.
Let me redirect your thought, and I apologize to you for this, because
That's
I had...
okay.
Part of the problem was in our discussions yesterday, what my understanding of the statement in particular was that I have been dreaming about killing her. And the statement is a little more oblique. It said, I have had a lot of dreams about killing her, which is maybe just semantics, but it's a little more indirect as a thought process. So the question then becomes, what is the probative value of putting your head on the pillow and having dreams about killing your wife?
in a case where the defendant is charged with killing his wife, it seems to be highly, highly probative that he's been having a lot of dreams,
Sure,
not just one.
On the surface, it is. I agree with you that the first immediate reaction is clearly that's relevant. Clearly, the jury ought to hear about it. I'm just saying, when you get down to the substance of it, though, what does it really mean?
When you get down to the substance of the...
What does it really mean that you've had dreams about killing your wife?
Yeah, and that's why I started the discussion with talking about our domestic violence evidence and showing that is circumstantial evidence of what you could call a fatal obsession with this woman. And here, it's almost as if he's saying, I have a fatal obsession with Nicole, except people don't talk like that. And the way that he expresses it is he says, I've been having a lot of dreams about killing her. And to me, that seems like it's so obviously powerful, compelling evidence of this fatal obsession with this woman that it's almost difficult for me to think to articulate, to put it into words. It's one of those things that almost seems to leap out.
You mean it's self-authenticating?
Yeah, I suppose you could say that, Your Honor.
Something like that. All right. Mr. Goldberg, how would you propose to present this, knowing the minefields that are apparent on either side of the sentence?
This is an issue that comes up over and over again, and we have a lot of experience dealing with it because we redact and change statements in courts of law all the time. And the way that this is handled is you speak to the witness.
I understand that.
Yeah.
I'm just saying, have you prepared to do that?
Well, I'm not going to be presenting this witness, but I'm sure that whoever does will sit down with him and explain the court's ruling. And,
I thought this was the next witness up.
Yes, but the court hasn't ruled on it. I don't know whether Mr. Darden has actually gone through and said, we're going to have a hearing on this issue. It would be rather difficult to explain to a witness. You may have to keep something out of your testimony, but we're not sure at this point. And it doesn't really take too long to give that kind of an explanation. So the proposal is you speak to the witness, you tell him exactly what you're going to be asking him, what specific question you're going to be asking about a conversation that took place on a certain date at a certain location. And did Mr. Simpson say something about dreams? Yes. Well, what did he say? And then the witness will give that one single sentence. So I don't see that mechanically that there's a lot of difficulty in terms of presenting that evidence, Your Honor.
I don't suppose either side has found cases that deal with admissibility of dreams.
No, I can't say that, quite frankly, we didn't even research that, Your Honor, because it seemed like our thought process was much the same as the court's, and that we were more concerned about the issue of the polygraph and redacting that out. I mean, the issue of relevance always turns upon a juror using their collective life experience and their common sense for the purposes of interpreting evidence. The counsel made this exact same argument about the domestic violence evidence, Your Honor. Well, just because you hit someone, it doesn't necessarily mean that you're later going to kill them. Just because you do these various things doesn't necessarily lead up to murder. But what we're always asking the jury to do with any kind of circumstantial evidence is use common sense, life experience, and that's all we're going to be asking them to do here.
All right, I'm going to give Mr. Douglas another comment simply because of the unusual nature of this.
Your Honor, thank you very much for this opportunity. There is clearly a minefield that we will be delicately walking around in between if we get into this particular area. And as well, Your Honor, we are going to be opening the door because in this instance, it's important to remember that on June 15th, 1994, Robert Shapiro sent a letter to Tom Van Adder asking and offering and accepting the request for a polygraph so long as the results were stipulated and admissible by stipulation. And therefore, Your Honor, I cannot simply rest on 7 certain words. I've had a lot of dreams about killing Nicole, and then move on to my next topic. Because before those words were uttered, there was a chuckle. And Ship will say there was a chuckle. And that chuckle does have significance because it might even arguably place into some question the seriousness of the statements that followed. Is he chuckling because the whole idea of a polygraph was funny because he's innocent and of course he'd pass? Is he chuckling because it's a silly idea because he's innocent and he throws in just by happenstance the sentence, well, you know, I've had dreams about killing her? Is he chuckling because the whole idea of having dreams is funny to him as well? Who knows? But to allow simply to have the words come up without allowing the context that traipses around a very delicate minefield of error and clear error, because we're talking about a code section that is mandatory and that is clear, because polygraph testimony is not admissible, because polygraphs in and of themselves have not developed the certain reliability such that they can be admissible. It's not even susceptible to a Kelly Fry hearing, Your Honor. The legislator has spoken as a matter of law, and it is binding. And because to do so would open up the doors about this letter where Mr. Simpson's lawyer 2 days later offered to take a polygraph so long as it was admissible, and in fairness, we'd want to bring that out to put it into the context that he really didn't have any dreams about killing her, and he really wasn't reluctant to take an examination. I think it's best and the proper course would be to let it all out, to keep it all out.
All right. Thank you, counsel. Well, no, it's just an unusual issue, and I just wanted to hear one more comment from the defense. I just wanted to solidify something in my mind. All right, the objection to the comments will be sustained as to any commentary regarding polygraph under Evidence Code 351.5, if I'm not mistaken. Point one. The statement regarding the dreams about killing will be admitted. Mr. Darden, are you going to be presenting this?
Yes, I am, Your Honor.
Is your witness prepared and instructed?
I'm going to need 10 minutes, Your Honor. He's in the building. He's upstairs. I just want to make sure he understands a couple of things.
All right. Any other minefields that I need to deal with before we invite the jurors? All right. As a matter of scheduling, I indicated to counsel yesterday that we would recess today at 2 o'clock because some of the court staff and some of the counsel have asked permission to attend a funeral this afternoon. I've indicated that I would allow them to do so, so we'll recess at 2 o'clock. We also have a 4 o'clock hearing as to Marguerite Simpson this afternoon, which I've asked Mrs. Robertson to contact Mr. Jones to see if he had another date. All right, we'll try to reschedule that with Mr. Jones. All right, Mr. Douglas.
Since there is, as a predicate matter, as a threshold matter, a challenge that the statement was even made, that the preliminary fact of the statement, separate from whatever inferences might be offered to flow, I would ask under 403 that there be a hearing as to that statement at an appropriate time. I don't want to take from the jury right now, but I would ask, Your Honor, that as a preliminary matter that be allowed, and secondarily, I would ask for my own purposes and my office's purposes that I be allowed to know that I can seek to obtain expert witness testimony about dreams, because I am going to intend to challenge any sort of probative weight that the people are going to attach to this alleged statement, which I contend never occurred.
Mr. Darden, you want to address that issue? 403 issue.
Not the psychic hotline issue, but the 403 issue, Your Honor?
Yes.
Your Honor, Mr. Douglas has a copy of our taped interview with Mr. Shipp. If the court would like a copy of that taped interview, I'm happy to provide a copy. I think it's inappropriate to interrupt Mr. Shipp's testimony at this point. Mr. Douglas knows what the witness has to say. He knows what he has said in the past. The witness is adamant that the statement was made. It's a question for the jury, an issue for the jury. to resolve. There's no 403 issue here at all.
All right. Mr. Douglas?
Because, Your Honor, this evidence is potentially prejudicial and risky, I believe, and because the court has one representation at sidebar about what is going to be said and another representation here in open court, there's another representation in a book where this witness's conversation has been reflected. There are aspects of this witness's background that I think will be probative for the court to evaluate preliminarily. I think the more prudent course would be for this court to first hear the entire statement so this court can understand why I think it important that I go into the circumstances and the tenor under which it's spoken before the court allows the jury to hear this certain statement. I'm not going to ask for a 403 with every particular witness. I do intend to ask for 403s with the domestic violence witnesses whom we dispute that the act occurred, that Mr. Simpson was involved in the act, or that there is the 1101B inference that is properly drawn given the factual context. On those instances, I will be asking for 403s. On this instance, because the court needs to preview the evidence, the court needs to understand why I say I cannot do justice to my client on trial for murder with the fifth witness in this case without my being able to vigorously cross-examine him on that particular point.
Mr. Darden, do you agree the court has discretion to conduct these 402, 403 issues before the jury and can strike testimony if the foundation is not there?
Yes, Your Honor, but this ploy pursued by counsel was one we've seen before, Your Honor. We saw it in the Chinatown murders. What counsel was really asking for is a dress rehearsal of a witness whose testimony is extremely damaging to his client. The court has a copy of a transcript of the taped interview. The witness is here. He is ready and willing to testify in a manner I believe will be consistent with that transcript. There's no 402 or 403 issue here. The court will just be wasting its time and giving Mr. Douglas, an extra shot at cross-examining our witness. That's unnecessary under these circumstances. It isn't fair. Mr. Douglas has known about this witness and his testimony for 10 days. And if he, let's get this on. Let's finish this trial. Let's stop dilly-dallying around.
Apparently it's in your book now as well. All right, the court will undertake the 403 examination during the course of the actual testimony. All right, we'll stand in recess for 15.
May I interject this? If we're going to have a 403, I would like not to have my witness's testimony interrupted moments before he provides this important information or testimony. If there is a concern, if the court has a concern and the court wants to do a 403 hearing, let's do it right now. Don't interrupt his testimony right before he...
Well, Mr. Darden, what do you want? Do you want the 403 hearing now, or do you want it during the course of the testimony?
I don't want it ever.
Take your pick.
Don't be so subtle with these things, Judge. I miss it sometimes. Thank you.
You're welcome. 15.